about what this is all about, right? And for me, it's about two things: abuse of power and weaponization of the law. This isn't just about me, and it's not just about Rappler. The message that the government is sending is very clear, and someone actually told our reporter this last night: be silent or you're next. So I'm saying, and I'm appealing to you not to be silent, even if, and especially if, you're next. You have to express outrage like I'm doing now. This is not, press freedom is not just about journalists, right? It's not just about us. It's not just about me. It's not just about Rappler. Press freedom is the foundation of every single right of every Filipino to the truth, so that we can hold the powerful to account. What we're seeing is death by 1,000 cuts of our democracy. And I appeal to you to join me. I've said this. I've been thinking about this for a long time. I always said that when I look back a decade from now, I want to make sure. That I have done all I can. We will not duck. We will not hide. We will hold the line. And, you being here, you standing witness, you asking tough questions, journalists and citizens, how we all derive our rights from each other. This is incredibly important for us in the Philippines today.
Maria, what is the action after your release? Of course, what's the plan?
Everything is new. It's funny. We should know what the law and what the processes are, but there's very small and big differences in the processes that lawyers go through all of it. You can talk to our lawyers about it. I think right now we continue to fight in court, and I will appeal again to the men and women in the Philippine judiciary, at the police, at the NBI. You are men and women, individuals with your own values. If you are asked to do something wrong, don't do it. You know the spirit of the law. Do not be manipulated. Violate the spirit of the Constitution. Our lawyers are working on everything. The immediate next step is to go and look at everything. Look at all the papers that were served and were not served. Why did a paper that was given to the NBI, the arrest warrant, that was imperfect, that didn't have the information for bail, why was that executed the same day it was given to them after the courts were closed? And then why was the one night court that was open with the ability to actually grant bail, why did it not post bail? Why was I not allowed to post bail last night? These are all questions our lawyers will ask. And, I think what I can tell you is transparent, because I have done nothing. Sorry. I have done.
Can you run us through what happened inside the courtroom earlier?
Sure. Process, right? Yes. What happened in the courtroom is posted bail. I posted bail. I guess there's one thing that someone asked me earlier, and I finally saw the statements by the DOJ. The DOJ said that this is really our fault because we could have, well, let me turn it around. DOJ, Secretary Guevara, who is, I thought, a professional, these are your actions. The ripple effects are what we feel in society, but you don't want to be known as the Secretary of Injustice. I also have the right to hold you accountable. I am a citizen of this country, and you cannot violate my rights.
Can you substantiate that? Why Secretary Guevara? Why is this?
Well, take a look. The cyber libel case, a case that was already thrown out by the NBI, number one. It was a case for a story that was done 7 years ago. When the NBI threw it out, it made the right decision, and then it magically appeared again a week later. I always say this is politically motivated, and I don't know why the government is afraid of the truth. They should be the first.
Why are you being single?
Maybe because I stand up and say things like this, but you shouldn't be afraid of that. In fact, it should make government stronger. That is the check and balance of journalism and government. We've done this through many administrations. I've been here before and I will be here after.
That's it.
Thank you.
Attorney JJ. Hi. Can we bring timeline of when the arrest warrant was issued, kailan ninyo nakuha, and how it was served, kailan ito na-serve? Can you just walk through this? So, the DOJ...
Ready ba lahat? Okay.
So, based on the record of the court, the information was filed by the DOJ February 6. As I understand it, a letter sent asking for a copy of the arrest warrant. Now, the judge signed the arrest warrant on February 12 and February 13 after office hours, after 5 p.m. Served the warrant on Maria Ressa at the Rappler office. And as you know, afterwards there were attempts for Maria to post bail in a night court, but the judges took the position that they had no jurisdiction. Therefore, this prompted us to file the motion for bail at the regional trial court that issued the arrest warrant this morning, and the release order was signed moments ago.
Attorney, what was Judge Monteso's ground for the probable cause where she ordered the issuance of the warrant of arrest? Have you able to read it now?
No, I've not read the determination of probable cause, but obviously the judge would not have issued the arrest warrant if she did not make her own assessment of probable cause in this particular case.
But you have a copy of the reso.
We have a copy of the DOJ reso, but the court doesn't issue a resolution with respect to the determination of probable cause. In other words, she agrees with the position taken by the DOJ.
How would you reply to that in further pleadings kung hindi niyo po alam kung ano yung probable cause na nahanap ni Judge?
No, I think the judge basically agrees with the determination of probable cause by the Department of Justice based on the records that are before her. And what we will do is we will file a separate motion to question the information that was filed and try to have it quashed.
Attorney, we're just curious, 100,000, is that normal for cyber libel under the cybercrime law? Kasi parang yung RPC ata 25K lang ang libel.
That's right. So under the Cybercrime Prevention Act, actually a lot of the offenses, the bail is 120,000, and if it's a critical infrastructure, it's 200,000. In the case of cyber libel, it's 100. So this is par for the course, or expected for cybercrime cases. The bail is quite high.
This is the sixth time that Maria posted bail. Is that correct?
Well, there were 5 other cases that were initiated against her, criminal cases where she had to post bail.
Sir, you were part of the tama po ba, parang consulting committee on the cybercrime?
No. Provisions I question was section there can be an independent one that is in play right now. So the question is cyber an independent time or under crime right?
Decided on the petition.
So the Supreme Court, in that case, in the cybercrime case, said that the the crime, cyber libel, is actually, it's the same crime under the revised penal code, except that the means or the way you violate it has been changed, meaning you violate it by, through, or with the use of ICT.
So in your view, yung prescription, same din sa RPC?
So my view is that the prescriptive period should be 1 year from the time of publication.
Sir, yung ano po, kasi sinabi niyo po, February 12, pinirmahan ni Judge Montesa
Yes.
yung warrant. 13 after office hours, saka po issue. What happened, sir? Were you notified of this the warrant? Meron po bang paraan that it would have nakapag-post kayo ng bail before it was served? Kasi yun yung sinasabi ni Secretary Guevara.
Yes, actually when I believe the statement of Secretary Guevara says that the information was filed 2 weeks ago. Actually, it was filed last week, and in the middle of last week, and I believe on Thursday and Friday the judge was not was on leave. So the first opportunity for the judge to look at the information was Monday. I guess what I'm saying is that, you know, when the DOJ files an information in court, there is no notice to the accused. There is no notice to the counsel of the accused. So we would not have any opportunity to address to take action against the arrest warrant being issued, because we would not be privy to the filing of the information.
Sir, you were mentioning clarification lang. You're filing a manifestation questioning the information?
It's called a motion to quash.
Motion, okay.
Motion to quash. So it's equivalent to a motion to dismiss.
When do you intend to file it?
We intend to file it within the week. So tomorrow is our target.
What would be your main argument for that?
The main argument is what I mentioned. It's a reading of the law that the interpretation taken by the DOJ has constitutional implications. What will happen is that if the DOJ says that the prescriptive period for cyber libel is 12 years, then that's a disincentive for people to speak out, and basically increases the criminal liability, not only of private individuals who engage in self-expression on the internet, but also of traditional media, right, or people in media publishing their work on the internet.
Sir, you're also questioning the application of the multiple publication rule because they cited jurisprudence.
Yes, because the multiple publication rule, I think, does not apply here. The correction that was made was a minor correction, which did not have any change in the imputation, because libel is a malicious imputation. So if the imputation was made in 2012 and the correction made in 2014 did not change that imputation, then I believe that the crime was consummated in 2012. Now, unfortunately, this was in May 2012, before the Cybercrime Prevention Act was even signed by the
Sir,
President.
can we just clarify, sir, what happened yesterday? I understand you were mentioning questions for the jurisdiction as far as the ninth court judge is concerned. Can we get more?
So the night court judges are Metropolitan Trial Court, they're lower court judges, and they didn't. And this case is pending before the regional trial. Was that since they don't have jurisdiction over the main case, they did not have jurisdiction to address the motion to bail.
Something that you do not agree with.
Yes, so we disagree with that. The rules of court does allow the municipal trial courts or the metropolitan trial courts to allow the accused to post bail. But this was not the position taken by the judges. Now, but of course there was another complication. Even assuming that they were willing, there was the complication of the fact that the information was not part of the arrest warrant, and therefore the judges could say, we don't even know how much bail to post, because the information was not as served by the NBI. So there were reasons really, even if the judges were willing, there were reasons for Maria to be unable to post bail last night.
Sir, normal bang format yung arrest warrant na walang nakalagay na set bail?
Yeah, but normally when the arrest warrant is served, the information is attached.
It's attached.
Yes, and then you'll be able to post bail on that basis.
Nasaan na yung information na yan?
Well, the information is with this court, no. But since it was after office hours and the courts are closed, there was no way for us to get a copy of the information.
Is it also something that you will tackle sa motion to quash?
They were not given a copy. The copy that was with them was only the arrest warrant. So
Natin support yung mga irregularities na yan, sir? Or hindi na kailangan?
at this point, because Maria's already submitted herself to the jurisdiction of the court, I think our next step is to attack the indictment itself, the charge directly, rather than the manner in which this arrest warrant was served.
Sir, the fact, as you were saying, the fact na walang information attached dun sa arrest warrant, that could have been one of the reasons why Maria is unable to post it, even if the METC judges wanted to. Is that also something you will tackle in your motion to quash?
No more. I mean, this is what we will attack in the motion to quash are the merits of the information and the charge filed with the DOJ. The manner in which the arrest warrant was served is unfortunate, but Maria has already posted bail. There is an order for her release, so I think we will leave that alone.
Sir Bert, could you go as far as saying that dun sa pag-serve ng warrant and all the alleged irregularities, may violation to due process na nangyari?
Well, I think it could have gone differently. I think if perhaps they had arrived earlier, or if we were given an opportunity to surrender. I think if we were aware that the case had been filed, we would have surrendered voluntarily. There would have been no need for a warrant to have been served and for her to be detained.
Sir, why should this case concern other online news publications or even bloggers who publish their content online?
Because, so if you're a blogger and you publish something in 2015, you would have believed that under libel, that no one could file a case against you now. With the position taken by the DOJ, anything you publish between now and 2012 is open for potential lawsuit. So there could be cases that other lawyers would have said, oh, you can't file that case anymore because the 1-year period has lapsed. Now those lawyers can say, look, the DOJ said it's 12 years, and now we can file the cyber libel cases. So there's a threat now, I think, for additional prosecutions for libel too.
Because you mentioned this has constitutional implications.
Yes.
Are there any plans to take this up to the Supreme Court?
So I think that these are new issues, right? And then I think there would be grounds to raise issues before the Supreme Court on particularly the way in which the Cybercrime Prevention Act is interpreted and how that interpretation impacts on constitutionally protected rights.
Sir, yung mga threats yesterday sa mga Rappler correspondents, taking videos, sinasabihan sila ng mga NBI na isusunod namin kayo, continue taking videos, may actions pa tayong gagawin, sir, because it's,
Yeah, so we're studying that. Obviously, from the standpoint of the Rappler reporter, the taking of that video is an exercise of freedom of the press. The arrest of Maria Ressa in the Rappler offices is a matter of public interest. It's newsworthy, and to the extent that the NBI somehow was restricting that may implicate freedom of expression or freedom of the press issues. But on the other hand, I think we also need to study whether or not there might have been security issues on the part of the NBI. There might be a need on their part to conceal their identity so as not to implicate them in other ongoing operations. So there has to be a balance. So we're studying that closely, and then we will make a decision.
Sabi ni Secretary Guevara, hindi prohibited yung pagkuha ng video unless it interferes with operations.
Yes, in that sense, that's what I mean. So to the extent that an NBI agent present in the Rappler offices might be involved in undercover operations, in other operations, it might interfere with those operations, and therefore, they could argue that that was necessary for them. So I think we need to study this more closely before we take any action. But certainly, offhand, the press has the right to cover a newsworthy incident, and so far as it does not threaten law enforcement in any way, then that is a constitutionally protected right. Okay, thank you.
Sir, pwede patingin ng